Welcome to the Animal Law Podcast. This is Marianne Sullivan. Today I'm going to be speaking with Amanda Howell. She is a staff attorney at the Animal Legal Defense Fund, and she's got a particular expertise in food law, and we're going to be talking about a case that kind of everyone's been talking about. This is the lawsuit that was recently brought in federal court in Missouri that is seeking to invalidate Missouri's legislative efforts to limit the sellers of plant-based and cell-based products from misrepresenting their products as, quote, meat. Whatever the hell that means, and as we'll talk about, it's pretty unclear what it means, which is one of the issues involved. And before we get to the interview, just please let me remind you that your support in keeping our hen house going. Our hen house, of course, produces the Animal Law Podcast along with the Our Hen House podcast, is desperately needed, and now is the time to help if you possibly can before the end of the year. If you can, please go to ourhenhouse.org/donate. And since before the end of the year, any donation that we receive will be doubled by our matching campaign. So that would be really, really great. And you can actually join the special band of supporters whom we call our flock. Or if you don't want to go that year, you can do more than that, or you can do less than that. Whatever donation you can afford is deeply, deeply appreciated. But please, if you can, do something. The only way we can keep animal-friendly indie media going is through supporting its efforts. And in this case, that would be Our Hen House and the Animal Law Podcast. But now to Amanda Howell. Amanda, as I mentioned, is a staff attorney at the Animal Legal Defense Fund, and she focuses on topics such as humane-washing, AgGag laws, and industry attacks on plant-based foods, which is what we'll be focusing on particularly today. And prior to joining ALDF, she co-headed the food law practice at the Stanley Law Group. And among the things that she was active in there was using state consumer protection laws to combat false advertising and deceptive practices surrounding food, beverage, and dietary supplements. Interesting, really interesting and important background for animal law practice, I think. Prior to that, she served as Assistant Director of Litigation at the Center for Science in the Public Interest. And I think you're really going to enjoy hearing from her and hearing about this lawsuit. Welcome to the Animal Law Podcast, Amanda.
I'm so pleased to be here. Thank you for having me.
It's a pleasure to have you. I'm excited to be talking about this case because everybody's heard about this case. But I'll tell you, I've been a little confused about what it's all about and the exact details of what's going on in Missouri and this law that has something to do with meat, but I wasn't sure exactly what. So I'm excited to delve into it. Before we get to it, though, I just want to, I noticed in your bio that you have a background in food law, and I think that's really cool, and have been thinking a lot about the fact that food law is a great background for people interested in animal law. Do you find that that's the case?
I do, and that's actually how I started getting into animal law. You know, a lot of the food system, you start to realize as you practice food litigation, it's very, very broken. And I started to see animal agriculture kind of as a root cause of all of those symptoms of brokenness. If you're talking about, public health issues, employment issues, the fact that, our food isn't safe, our food isn't healthy. And it's because of this factory farming model that we have. And so I really saw animal law as a way of kind of getting to that root cause. And, if you change things at that level, then everything else, I saw would change. So,
yeah, that's great. I really encourage law students not everybody has food law available to them. It's not even taught anywhere. But I think if you're interested in animal law, it's a great thing to look into to see if you can pick up a course in that.
Yeah. And it's kind of helped with this case too.
Clearly.
Something that, one type of case that we tend to bring at Animal Legal Defense Fund is, humane washing or false advertising cases. And people who have a background in food law are intimately familiar with using consumer protection statutes to go after different misleading practices, misleading consumers. We'll see a lot of animal agriculture products trying to make themselves seem healthier or happier than they really are, and using those unfair and deceptive acts and practices statutes really is one pretty effective way of going about curing that.
It sounds great. And I wish I had more of a background in it myself, but I'm going to learn a lot today. And let's start with this statute. Like I said, I think a lot of people listening may have heard about this statute in Missouri, but can you tell us exactly what it provides?
Yep. So back in June, I think it was signed into law, and it went into effect at the very end of August. Right before it went into effect, we filed our lawsuit. The actual language of the law, and it's as bizarre to you and your listeners as it is to me, the law prohibits misrepresenting any product as meat if it doesn't come from, the quote is, harvested production livestock or poultry. And what harvested production livestock or poultry really means is from a slaughtered animal. And the first part of that, misrepresenting a product as meat, that's incredibly vague, as I'm sure you can tell. What does that mean? And what does that mean to any one of the 115 county prosecutors tasked with enforcing this law? Because interestingly, this law is actually a Class A misdemeanor. This is a criminal law. It's punishable by incarceration of up to 1 year. So
it's pretty crazy.
Yes.
Especially since I think one of the reasons I've been confused about it is because whenever I read about it, I would see it and I would think, well, there must be more in it than I'm reading. This is just an article about it, and I'm not seeing all the details. But no, there don't seem to be any details. It just does it. And another thing I've been unclear about, and I guess other people are too, whether it just prohibits the use of the word meat or whether it goes much further than that.
I think part of the scary part about this law is that it could go incredibly far. I think it goes, it's up to the interpretation of a county prosecutor. So if that county prosecutor says this product is misrepresenting itself as meat, I'm going to enforce it. That's fine under this law because it's so vague. And that's actually one of our claims against it is a due process claim for vagueness, that it's void for vagueness. But jumping back to whether it just prevents companies like Tofurky, who is our plaintiff here, from using the word meat, I would say no. I would say it does do that, but I think it would also prevent plant-based companies right now who are on the market selling products in Missouri and clean meat companies who hope to be on the market nationwide within the next year or two from saying words like sausage or hot dogs. Right now, I think Tofurky has a couple products. Chorizo style sausage, plant-based hot dogs, vegetarian ham roast, things like that. And if a county prosecutor, any one of 115, says, I think that means it's misrepresenting itself as meat. But even more so, I think that it could also apply to the principal display panel of these products and also the marketing of these products. So it's not just what people see in stores, it's if they go to websites. I think that a picture of, let's say, the Tofurky deli slices, those, they resemble meat. They are meant to be used like any other deli slice to make a sandwich. So even the picture of the product itself could be seen to be misrepresenting itself as meat. I know that there are some plant-based companies on the market right now that use pictures of, chickens or cows made up of vegetables, but it's still the image of an animal. And that might be another way that a prosecutor would want to go after plant-based companies.
Yeah, it is pretty crazy that the language here actually is misrepresenting a product as meat when it is really impossible to understand what the hell that means. Mm-hmm. I mean, I seriously have no idea. And also, this is totally an aside, but it seemed to me because if it applies to anything that's not derived from, quote, harvested production livestock or poultry, like if it would apply to venison, if the deer were hunted. I mean, it would apply to things that actually are what everybody in the world would consider meat, wouldn't it?
I think that, so meat and harvested production are defined elsewhere in the statute. Mm. I think that includes anything from cattle and sheep and swine to things like ostriches and emus, and it pretty much runs the gamut. So it's pretty broad. Okay. But the two big things is it would apply to plant-based meats. Obviously, it's not. Those don't involve the slaughter of any animal. I know you're not worried about the venison, the venison industry. It just seemed like it wouldn't even apply to that. But that's, as I said, that's an aside, and we don't have to go too far down my byway here. But there is some guidance, right, as to what
the statute means in using the word meat, and I think the Department of Agriculture supplied some guidance.
Yeah, it was actually in the form of kind of a memorandum or an enforcement memorandum. And I don't think that they did it necessarily to give clarity. I think that they did it to make the law a little bit less unconstitutional. I kind of see it, this memo, as some kind of implicit acknowledgement of the potential constitutional problems with the very natural reading of the law. And so it does inadvertently, I'd say, give some clarity in terms of what it applies to, and also what the Department of Agriculture would say is misrepresenting a product as meat. That said, the Department of Agriculture in Missouri is not the one tasked with enforcement of this law. It's the county prosecutors. And while the Department of Agriculture can recommend certain things for enforcement, and that's basically what they're saying here, is if you comply with this memo, we won't recommend your product for enforcement. That doesn't stop county prosecutors from going after whatever they really want to. They don't just have to take cases recommended to them. And also, the fact that this memo has been issued doesn't change the fact that we still have an unconstitutional law on the books that, companies like Tofurkey and any number of plant-based producers who currently sell in Missouri are basically in fear of being thrown in prison. The CEOs of these companies could be jailed for a year based on someone's interpretation. And, so that's problematic. I also think that other states are kind of looking to this law and how this litigation goes, because it was really brought up by the Missouri Cattlemen's Association. They came to Senator Sandy Crawford and said, we want to, have this fake meat bill. We're basically seeing this as a threat to our industry. And the fact that there are cattlemen's associations in basically every state across the United States, I see that, this is something that they might like to do state by state. And so, this is a very important legal challenge because of that.
I mean, when I saw it, I thought this is definitely a model, but I'm glad to see that my instincts were correct about this Department of Agriculture memo. It just showed, there's just something confusing about this, that the Department of Agriculture thinks that it can interpret a criminal statute. And their interpretation was much better. They did provide some clarity, and maybe you can tell us a little bit more. But the Department of Agriculture can't be in charge of interpreting. It's like they don't even know that they're different entities. It's so confusing, and I thought maybe I was crazy, but you're telling me I'm not. So
no. You're definitely not crazy.
Missouri's crazy, not
me. A little crazy, yeah.
But let's talk a little bit about it, because it is a lot more reasonable, and it does provide a lot more clarity, doesn't it?
So,
assuming that it were applicable, which it's kind of not, but if it were.
It's non-binding, and I agree with you that it provides some clarity, but I might disagree with you that it's reasonable. In terms of clarity,
I just said more reasonable. Okay,
more. I don't even know if Mary, I'm sorry, I'm a fan, but I don't even know if I agree that it's more reasonable. It gives the plant-based company. Well, first I'll get into the changes, or what they say. They won't recommend for enforcement for. They basically give two things two kind of guidances. They say that the Missouri Department of Agriculture will not refer products if their labels contain, first, a prominent statement on the front of the package immediately before or immediately after the product name, that the product is plant-based or veggie or something, lab-grown. And again, or a comparable qualifier. So here we have two, so it's trying to give some clarity, but we already have two things that are up for interpretation: a prominent statement. So again, we still don't know what prominent means, neither would a county prosecutor, and a comparable qualifier. So, I don't know what those two things mean. That's not very specific. And it, at the same time, is pretty restrictive. The front of packages is really valuable real estate. Having practiced, in food litigation for a very long time, kind of got a sense that, that is basically the 10 seconds that products have to convey the nature and contents of the products to consumers, to kind of say what's different about their products, to make their products, sellable, make someone want to buy it. So having these restrictions, like you have to have plant-based right after veggie sausage. So, it's telling plant-based companies exactly how they can, market their products. And that's something that is not the case. That's something that Missouri does not do to, meat products. So really what we're trying to do here is level the playing field. And that first prong here set forth by the Department of Agriculture, again, it's still kind of putting plant-based producers a step down and wrong-footing them, and by telling them exactly how they can and cannot market their products. It would also require a change. If that's not how you currently market your product, you're going to have to go back and change all of your products, change all of your marketing, every single depiction of your product online or, who knows where is going to have to change. And that's incredibly onerous, incredibly expensive.
Yeah, I noticed also, and correct me if I'm wrong, but there was something about how you can, if you can't figure it out, you could always go to the Department of Agriculture in Missouri and work with them to figure out what will pass muster, which, on its surface might seem reasonable, but every producer has to go to Missouri and talk to the Department of Agriculture and say, do you like our label in order to do business in the United States? That seems pretty tough.
It is. And so, it's kind of it would force plant-based producers from either having to jump through all these hoops or just not sell in Missouri, which means probably not selling in the entire region. What it seems like they're trying to do is get pre-market approval for labels of products, which, plant-based products anyways are under the jurisdiction of the FDA. So there aren't any pre-market approvals of labels for all other, plant-based foods and foods that are regulated by FDA. So the fact that Missouri is trying to do that is, incredibly restrictive and onerous.
Yeah, it was also something of a concession that the regulatory scheme was still unclear if you have to go running to them every time to make sure that you fit into it. But didn't Beyond, this I'm pulling this out of my hat, so I'm not sure this is true. Didn't Beyond Meat enter into some kind of consent agreement regarding its products under these rules? Is that ringing a bell in my head?
I think I know what you're talking about. Well, Beyond Meat I think they have brick and mortar production facilities in Missouri. So I think, it's even more bizarre to me that this law would get first passed in Missouri, because here we have a plant-based company providing jobs and helping the local economy. So I do think that maybe Beyond had a little bit more incentive to work with the executive here, but I think that maybe this memo is the result of that.
I see.
Yeah, but again, it doesn't cure a lot of the problems that this law has for me. Again, the law is still in the books. This enforcement memo is non-binding. And the two things that it's asking plant-based companies and clean meat companies, let's not forget about that, to do, I think is still incredibly restrictive and onerous. And what they're trying to do basically is require disclosures instead of a restriction, and kind of maybe get around the whole First Amendment constitutional issue that way. And also saying that they won't make any referrals until January 1st, 2019. That's right around the corner. This memo was issued a few months ago. So basically you're giving giant companies or tiny companies 4 months. A total of 4 months to change all of their marketing and packaging. That's not that's
crazy.
Not enough. Yeah, no.
So can you give us a little bit of, moving off of the interpretation from the Department of Agriculture, just taking a step back and give us a little bit of the legislative history. How did this all come about?
Yeah, so this actually got passed as part of an omnibus, but it started with a bill proposed by Senator Sandy Crawford. And Senator Sandy Crawford, I think, has cattle herself. She is, has very close ties with the Missouri Cattlemen's Association, and she openly acknowledges that this, bill that she presented, the impetus was the Missouri Cattlemen's Association. She said they came to her with this, and because that they wanted to protect their cattlemen in Missouri and protect our beef brand. Well, that's not the reason that they gave for passing this law. We have to have a substantial government interest here in order to have the law pass constitutional muster. They're saying that substantial government interest is protecting consumers who are so confused about plant-based meats that are on the market, which is, I think that strains credulity. But so if you look at the legislative history, which is, that's publicly available, we have a lot of people sitting around talking about how they have to protect the animal industry, how we have to protect our beef brand. I think Cattlemen's Association, Grassland Beef, the Farm Bureau, Missouri Pork, all these, interest groups are donating thousands and thousands of dollars to the exact lawmakers who introduced the legislation. So, I have to be incredibly skeptical about their motivations for putting forth this bill.
You think they're trying to protect their industry from competition, not from confusion. Mm-hmm.
Exactly. Yeah, I think this is anti-free market protectionism, basically the definition of that.
I've also seen the argument by the industry, not necessarily in the context of this lawsuit or any other lawsuit, that, and I think this is a better argument for them, that people are deceived not by the idea that this is made out of plants, but by the idea that it has the same nutritional profile as meat. Have you seen that argument? Which I think is, it's actually kind of a good argument for them because it goes beyond this ridiculous idea that people are deceived. For me, it's a pretty bad argument because their nutritional profile is so terrible. But but is that an argument that you're seeing?
That I think they're probably borrowing a page out of the dairy industry's book there.
No, I see that in the context of dairy. Yeah.
Yeah. So that's not something that was, really discussed in the legislative history. But, if they were to make that argument, that's pretty clear. I think that they would still have to somehow show that consumers think that different products, completely different products made of completely different things have the same nutritional value. And that's not the case.
It does depend on remarkable stupidity assumption of remarkable stupidity on the part of people buying these products.
And they're asking us to think that consumers are very unsophisticated, that don't know the difference between a tofurkey vegetarian ham roast and a dead pig that's been rotisserie'd. So I can't see that argument holding much weight or holding much water, but I wouldn't put it past them to make that argument.
Yeah. I think the reason most people buy it is because they know it has a different nutritional profile and they prefer the nutritional profile of these products.
Exactly. People are drawn to these products because for a number of reasons, and not just the animal welfare reasons. This is not just consumed by vegetarians and vegans, but anyone who's concerned about environmental impact of meat, the public health, and the impact on their health that consuming products like cow red meat has, or any meat. So it behooves plant-based products to strongly advertise the fact that they're not meat. They have an incentive to differentiate themselves as strongly as possible. I think that's what they do. No plant-based producer on the market right now wants to be confused with meat. So the fact that the Cattlemen's Association is saying that after the fact, and the fact that the statute relies on that assumption is ludicrous to me. I think what we have instead is the fact that plant-based meats grew 23% in the past year, whereas, every other food category is struggling to get 1 or 2% growth. This is something that they're definitely sitting up and taking notice of. They're very afraid of losing market share. They're very afraid of consumers kind of turning on their product because of the environmental, animal welfare, and health implications. And I also think they're very afraid of clean meat. There's been a lot of interest and investment in clean meat, or lab created, whatever.
Yeah, what are we calling it these days? I know the industry likes the word lab to be in there.
Yeah.
Personally, I'm a fan of cultured, but I don't know. I think I'm losing that battle. I mean, obviously the movement was pushing clean, but that seems to have softened a little bit lately, and I'm hearing cell-based a lot. So
cell-based seems to be the
new hot term.
trend.
And I don't like it as much as cultured, but nobody listens to me.
I'd say I like it if we got slaughtered animals to be called slaughter-based meat or
perfect.
some other hyphenate. Yeah, I'd be on board.
That would be fine. I know you alluded to this, but before we get into the lawsuit itself, I just want to go into a little bit more. How clear is the advertising and the packaging on the plaintiff? Obviously your plaintiff is Tofurky, but there are other producers too. How clear is it to consumers? And probably most people listening to this podcast know how clear it is because they buy these products. But how big an effort is made to make it clear that these products are plant-based?
I think incredible efforts are made to make sure people know it's plant-based because, again, that's why people are buying them. It goes from anything from that principal display panel, that, front of package. You'll see different kind of qualifiers or disclaimers. Like I think Tofurky has a little guy saying, I'm vegan, and obviously it says plant-based everywhere. Or, and that's another thing, the semantics between vegan and plant-based. I'd really like producers to be able to call their products or, be able to differentiate their products however they want to, wherever they want to, as long as it's clear. I think they're already doing that. I don't think anyone's going to the store picking up something that says made, with the power of plants, plant-based, vegan, blah, 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 all over the package. And even the names of the statements of identity here that we have, it has chicken, but it's not spelled like a chicken. It's with an apostrophe, or chorizo style sausage. It's clear through a number of different methods, I suppose you would say, but the bottom line is the same. It's incredibly clear. I don't think there's any evidence of consumer confusion. We've never seen FDA take up enforcement action. FTC hasn't taken any enforcement action against a single plant-based producer. Before filing this lawsuit, we filed a public records request, and just to see, is this some kind of problem we're not aware of? And no, there hasn't been a single consumer complaint to the AG's office about plant-based meats.
Yeah, but as you say, they're probably worried about what's going to happen when the products aren't plant-based, but are cell-based or cultured, as I like to call them, or cultured, which is going to be a different battle on how they are identified, because there is going to be much more similarity. So yeah, they do seem to be jumping the gun a little bit on worrying about that.
I think that hits the nail on the head. How are we passing laws saying how cultured meat can and cannot market itself before they're even on the market, before you've even seen a single package? That's, to me, pretty crazy. Again, jumping the gun. And also, we're looking that FDA and USDA are going to have joint jurisdiction and enforcement here. We don't even know what the regulations are going to look like. For all we know, that clean or cultured meat might have pre-market label approvals, just like other meats. So, if that's the case, then are we going to have a situation where USDA or FDA says this is a fine label, but that label is not fine in Missouri? That's, again, it's pretty illogical.
Yeah, no, there are going to be a lot of issues, and it seems to me that the industry is just, their anxieties are rising, as we like to say on our in-house. Like they're so worried about this, they're kind of jumping the gun on it almost. But here we are, and they passed this law, and Tofurky and all of these other producers of these products are very worried for very good reasons. So let's get to the lawsuit. All right, let's start with the basics. Exactly what court are you in, and who are the parties?
We are in the Western District of Missouri, and our
plaintiffs in federal court.
Yes, and that's a good thing. The parties, we have Tofurky, as you know, a very principled company and really wanting to do the right thing here, and they do sell in Missouri, and they do have these disclaimers on their products. I don't know if all 115 county prosecutors would agree this isn't misleading, but they are in reasonable fear of prosecution and being thrown in jail, basically. So that's Tofurky. We also have the Good Food Institute as a plaintiff because they do represent the interests of both plant-based producers and cultured meat producers. So those are our two plaintiffs, and we filed back right before the law went into effect, which is the end of August.
And who are you suing?
We are suing the named defendant is Mark Richardson. He is a Cole County prosecutor, but he is named as a representative of a class of defendants that encompass the entire group of prosecutors in Missouri.
Am I behind the times? I mean, I just think of class actions as being plaintiff classes, not defendant classes.
No, that's usually how it goes.
All right, so I thought I missed something in law school or something.
No. And this is actually kind of a new one for me too. My entire career I've been bringing plaintiff side class actions, so it's kind of fun to be bringing a defendant side class action. But we need all of those prosecutors to be grouped as a class. Otherwise, if we just get a judgment as to one of them, then that still leaves everyone else. So it's our way of getting everyone who's tasked with enforcement of this criminal law for it to apply to them too. I will say that the Missouri Attorney General's office did move to intervene. It was an unopposed motion to intervene, and that was just granted the beginning of this month. So now we will be the defendant is the Attorney General, as well as Mark Richardson in his capacity as a class representative.
And okay, so let's get to the causes of action. Your first cause of action is a 1983 civil rights cause of action based in the First Amendment. And can you just lay out what you're claiming here?
Yeah, of course. So what we have here and what we've been discussing is, companies are engaging in truthful commercial speech. This law is unconstitutionally restricting truthful commercial speech. And commercial speech is protected, even though, it's commercial speech and it's not made on the part of individuals. That includes words on labels and advertisements. That's still protected. So what happens here is this. As long as the speech is truthful and non-misleading, which is the case with all plant-based products on the market, then the government must have a substantial government interest in restricting the speech in order for that law to be constitutional. And also the restriction, this law, can't be any more extensive than necessary to achieve that interest. And, if people recognize this language, it's because it comes from Central Hudson, which is applying an intermediate scrutiny to the law.
And you pointed out in your papers that there might even be a stricter, you're using Central Hudson for your analysis, but there might even be a stricter level of scrutiny under Sorrell?
That's right. Yep.
So Central Hudson would be the minimal level, and can you just
and they don't even meet that? Yeah.
Can you just explain, since everything depends on what level of scrutiny is called for in First Amendment cases, why is this a content-based restriction?
It covers just the basic things, the PDPs, everything that is already on the market. It doesn't matter if And it's the fact that it's targeted at plant-based producers.
All right, so you have to show, they have to show that the speech is false or misleading, and that's basically the threshold question of the cause of action. And there's a difference between whether it's inherently false or misleading or potentially false or misleading. Is that right? Can you tell us what those differences are?
So inherently false or misleading is something that they would be able to pass a law to prohibit all inherently false or misleading speech. And, then they would have a lower level of scrutiny. But here, you can't take a look at all of the producers at once. And so it's going to be by a case-by-case basis to determine whether the labels of these products are false and misleading. It's not something that you can say as a matter of law that all plant-based producers' labels are false or misleading. So that's the difference between inherently misleading and as applied.
Okay, so that makes sense. Like inherently misleading is just it's outright wrong. Everything everybody's saying is wrong. Here, you have to look at everything and say, could that possibly potentially confuse a consumer?
And again, how many plant-based companies are on the market right now? You would have to take a look at each individual product, and each company has several products on the market, right? So making a law that says all of them, we're sweeping this under this one giant broad rug, that's, I think that's going to be a burden that the government is completely unable to meet. There are a lot of, it doesn't meet that last prong that the restriction isn't any more extensive than necessary. It's way more extensive than necessary because, again, I don't think that there's a single product on the market that is misleading. But to say that all products on the market are misleading is, I think that is something that the government is not going to be able to show.
Yeah. So if there were one product that was saying real meat, that might be misleading, but they can't put these restrictions on everybody because that one product could, even though obviously it's not on the market, even just because it could be.
Exactly. And I think some FTC guidance on commercial labeling has been out there, and that basically says that let's err on the side of allowing free speech, allowing companies to convey information to consumers, and that what we really should be doing is attacking any misleading practices on a case-by-case basis. That's clearly not what this law is doing here. It's not, going after anything on a case-by-case basis. It's attacking an entire industry.
So, and it's the defendants who would have to show that no other possible remedy would be able to achieve this government interest of avoiding consumer confusion, right? It's not. That's right. It's not your burden to show that. They have to show that this restriction is the narrowest that they can impose in order to protect this interest.
And I don't think that they'll be able to do that again. And this was in the papers too. There are several different restrictions already in place that prevents false or misleading advertising for foods. The thing that we started this conversation talking about, state consumer protection laws. Missouri has one on, it's Missouri Statute 580. It's already preventing any false or misleading statements in the promotion of goods for sale. So if there were plant-based producers that were selling misleading things, like in your hypothetical, like this is real meat when it's not, that the AG's office or any consumer could go after that product.
Right.
Again,
it's
on
not
a case-by-case
surprising
basis.
that there would already be a law in place that would say that lying about what your product is yeah.
Right. So there are state laws in place, but there are also federal laws in place. FDCA, which is what the Federal Drug and Cosmetic Act is, what applies to all plant-based foods, and that prevents misbranding or any statements that's false or misleading in any particular. Again, FDA would be tasked with enforcing that, and we haven't seen any enforcement because there isn't any misleading products on the market. But if there were, FDA would have jurisdiction to go after those. So there's plenty of layers of protection and preventing consumer confusion. That's already taken care of. So the fact that this law is passed, what's it doing that, state consumer protection laws and the FDCA is not doing?
Well, let's talk a little bit about what the government thinks its substantial interest is. And this may seem obvious to all of us, but why is protecting the meat industry in Missouri, which is a big industry in Missouri, not a legitimate substantial interest for the government?
Yeah, that's just anti-free market. That's industry protectionism. That's not, that can't be considered a substantial government interest. We have, actually, it's unconstitutional for states to just protect things in their own state, at the result of restricting stuff outside of it. That's our Dormant Commerce Clause claim. It's
I want to get to that in a second.
Yeah,
but just the whole idea that the government is not allowed to favor one industry over another. But their basic point is that what they're doing here is protecting consumers. And you have a much easier argument for saying this isn't really protecting consumers.
Right. They're not saying that the substantial government interest can be protecting their industry. And they know that. So again, they go to, we're protecting consumers. Because that is a substantial government interest if that is indeed what they were doing. That's not the case. Again, they would have to show, the burden is on them to show that there has been, they would have to show with empirical evidence that consumers would be confused or deceived by the use of, these words and claims by the part of plant-based producers. That's not something that they're going to be able to show. Again, these packages are very clear. There haven't been any, class action suing over, confused consumers for plant-based meats. FDA hasn't taken any enforcement action. FTC hasn't. Their AG's office hasn't. I can't imagine them even commissioning some kind of at all objective survey that would show that people are confused. Again, just on the face of these products, people understand what they are. So that substantial government interest in protecting consumers from confusion just doesn't exist. Consumers aren't confused.
Yeah, and let's talk about the Dormant Commerce Clause issue for a second. That's your second cause of action. Can you lay out exactly? I mean, for people who aren't familiar with the Dormant Commerce Clause, which comes up so often in animal issues, I don't know why, but so it's an important thing to know about. Can you explain exactly what that is and why you think this fits into that analysis?
Of course. So again, this is Missouri, and they have passed a law that applies to all companies, even outside of Missouri. Now, if they were just protecting their inside interest against outer state interests, you'd apply Pike balancing, Pike v. Bruce Church. Basically, courts weigh whether the burden to out-of-state producers is clearly excessive in relation to the putative local benefits. And whether that burden is acceptable depends on the nature of the local interest involved and whether it could be promoted with lesser impact. So again, we have less restrictive things as part of that balancing test. But even if a statute even-handedly imposes a restriction on, and it's not just out-of-state producers. It applies to even Beyond Meat, who is in Missouri. It still can be declared invalid if the burden that it imposes on that commerce is clearly excessive in relation to those putative local benefits.
And why are the benefits local? I mean, because it's not just Missouri that produces meat. Does it particularly favor Missouri agriculture?
So let's assume that the court believes that this is to protect consumers from confusion. Let's weigh it in relation to that putative local benefit, because I think that's what the AG's office is going to have to say here, because again, they can't say, yeah, this is totally to protect the industry, because then that's basically admitting that they are violating the Dormant Commerce Clause. So let's say they say, yes, this is to protect Missouri consumers. So that's the putative local benefit, curing any consumer confusion. Yeah. And that is going to be weighed against the burden to interstate commerce, which is incredibly onerous. Again, we're looking at millions and millions of dollars of marketing changes, packaging changes, lost money from companies saying that, I don't think we can sell in Missouri and without risking being thrown in jail. So those are, that's a very heavy burden on interstate commerce. And you weigh that against, again, consumer confusion, which, again, there's no evidence of consumer confusion. So I don't see how that balancing goes well for the state.
That makes much more sense than my. I got drawn into their real reason for passing this statute was to protect the Missouri meat industry, not into their fake reason, which was to protect Missouri
which is
consumers.
The one that they're going to put forth in front of the court. Yeah, right. Because again, the real reason is one that we aren't acknowledging. The one they're not acknowledging, it's hush hush. Yes. But we all know that's the real reason.
Now, your third cause of action is a due process cause of action. Is this basically a vagueness challenge?
It is. Yeah. It is.
Well, we've already talked a little bit about how completely vague the statute is, which I still can't figure out what it means. Just reading it, it's just impossible to understand what they are prohibiting.
I think the problem is it could mean pretty much whatever a county prosecutor wants it to mean. And I have to imagine that the Missouri county prosecutors are just as beholden to, the cattle industry and the pig industry as, the legislators who passed this law. So it's so vague and it's so broad that, everyone is sitting on tenterhooks basically to see if they are going to be, again, thrown in prison if they're going to be prosecuted.
So what relief are you seeking?
Basically, to overturn the law is unconstitutional. We would like the court to agree that this law cannot be enforced, that it is violating the First Amendment and unconstitutionally restricting truthful commercial speech, and that no county prosecutor can enforce it. And as we talked about earlier, the AG's office did intervene with and the way that AG's offices can intervene is to defend the constitutionality of statutes. So that's what we're going to be fighting with, is just over those constitutional issues. Interestingly, the named county prosecutor, he filed his answer to our complaint and to our motion for preliminary injunction that we just filed back at the end of October, and he takes no position on the constitutionality. He doesn't, say it is or isn't constitutional, and he doesn't oppose any relief that we're seeking.
Wow.
So, yeah.
Too bad you don't just have him as opposing you.
But then we wouldn't be able to get to the constitutional issues, which is something we would like decided again, because, I think the court is going to be able to see that this is anti-free market protectionism just at its, basis, and hopefully dissuade other states and other cattlemen's associations from putting forth similar legislation.
Yeah, I agree that that's the real risk here. That if this is upheld, it will be everywhere very soon. So, is there anything in your seeking a preliminary injunction that we haven't covered? We've certainly covered likelihood of success on the merits. You've laid out all of those arguments.
Right. I think that the real reason that we need the preliminary injunction is because this, it went into effect at the end of August. So from August until today and going forward, and until a preliminary injunction is granted, all of the plant-based producers that either sell in Missouri, and even ones that just have, basically websites that a Missouri consumer could go to and be, quote unquote, misled by, they're all at risk of being prosecuted. So that is something that we need, decided before the end of this case, before we, duke it out for months and months. This is something that I think we need to stay the enforcement. That's what the preliminary injunction would do until the constitutional issue is decided.
And what are the next steps in the case?
So, as I said, the Attorney General did just intervene, and they filed an answer. And we do have a pending motion for preliminary injunction that the Attorney General's office will have to file a response to. But actually, we have a mediation set for mid-January. I think that may be because, we have that additional guidance from the Missouri Department of Agriculture, and they're hoping to kind of craft. My guess is that they would be hoping to craft something similar to that. We would say, oh, that's fine. Plant-based producers and clean meat producers can have additional labeling regulations and requirements than any other company, and we'll all go home happy. But first of all, that I think that having any additional restrictions and hoops that plant-based and clean meat producers would have to jump through is not having a level playing field. That it's not a free market. It's anti-business, and I hope that regardless of someone's diet and regardless of the judge's feelings on plant-based products, I think that anyone can say that we don't want industries using state laws or even federal laws, which we've seen with the Cattlemen's Association, to kind of shore up their own industry whenever they get scared or whenever they lose market share. That's not what our laws should be used for.
So you think that they're going to suggest enacting those provisions into law, or something similar to them?
I think that the way we would have to go about it, if some kind of settlement were reached, I think that would have to take the form of some kind of consent decree or consent order from the court, because again, we wouldn't want just this to apply to our plaintiffs, the Good Food Institute and Tofurky. That's usually how settlements go. It's the named parties. We would want to protect, obviously, all plant-based producers and clean meat producers in the future. And if that settlement were just for the named parties, that wouldn't apply. So that's how I think it would work procedurally. But
you're not really interested.
I'm interested in hearing what they would have to say. I'm interested in having a good relationship with opposing counsel. As always, everything should always be reasonable and respectful. But again, given that I can't see any scenario where we aren't additionally restricting or at least requiring disclosures, which might be a little more justifiable if there were consumer confusion. But again, until I see any evidence of consumer confusion, I don't understand why we would have these additional restrictions just for plant-based producers.
Well, that has all been extremely enlightening. Obviously, there's a lot to be rolled out in this case. We'll all be looking forward to hearing what happens because, as you've pointed out, this could go nationwide and it could be hugely important to the growth of these industries. Is there anything about this case that I should have asked you that I haven't?
I think we pretty much covered everything. It's just, I know that everyone who listens to this, cares about animal law, but again, because this is a constitutional issue, I think that everyone should care about this because again, I think it's very disturbing to see industries basically telling the government what kind of laws to pass in order to protect those industries. I think that anyone should be concerned by that. So this isn't just important for plant-based products and protecting animals and clean meats. I think that this is kind of a core question of what we use laws for and what's proper and what's right. So
yeah, no, that's a really good point. This is innovation, and if the law is going to be used to prevent innovation, just because companies that already exist are going to be hurt by that could be very harmful.
Exactly.
Well, thank you for sharing all this time with us, Amanda, and it's been very enlightening. We'll be looking forward to hearing what happens.
Thank you so much. This has been really a pleasure.
Thanks so much for joining us on the Animal Law Podcast. We'll be back next month with a new show. And thank you especially to Amanda Howell for taking the time to explain this case to us. And thanks also to Michael Herron and John Frusciante for their help in producing the podcast. If you like what you hear, please subscribe on Apple Podcasts or your favorite podcatcher. If you're not already subscribed, please consider leaving us a good review on Apple Podcasts. That really helps us reach new people. And if you're able, as I mentioned, consider making a tax-deductible donation at ourhenhouse.org, especially if you can fit it in before the end of the year. Thanks so much for tuning in.